Welcome to SG classes, sir. So, today we are going to discuss the previous exam questions on the Indian Contract Act. Sir, whatever we are going to discuss now, that will come in the exam. 90% questions will come from the previous exam question papers only. So, in today's lecture, we are going to discuss the MTPs, model test papers, and revision test papers, and previous exam question papers from the Indian Contract Act, chapter number 1. This is the real depth of the exam, sir. Sometimes you feel that when faculty is teaching in the class, you feel very comfortable. You can able to understand everything. But when you're writing the exam, you feel very discomfort. You're unable to write the questions. You're unable to write the answers for the questions in the exam. Why? Because what we teach in the class is different. What they will ask in the exam is different. The depth of the concept will be different, beta. So the depth we're going to discuss in today's class. Hai na, beta? So the first chapter, let us try to understand. First of all, how many types of questions are there in the exam? There are 3 types of questions will come in the exam, beta. CA Foundation, or CA Intern, or CA Final. There may be law or auditing. 3 types of questions will come in the exam, sir. Foundation, Inter, Final. First question, case law based question. Case law based practical question. Second one, section based practical question. Section based practical question. Third one is the direct question, sir. If 10 questions are there, no, out of 10 questions, 4 questions will be this kind of questions, beta. 4 questions will be section based questions and 2 questions will be direct questions. Direct questions means define the essentials of a offer. This is a direct question. Define the consideration, direct question. And but majority of the questions will be practical questions, beta. He will give ram and beam. So they are doing like this, and the dispute between the ram and beam, and you have to decide. Hai na? Practical questions will come. So if it is a case law based practical question, for example, beta, in the exam he will give a question similar to Mohiri Bibi versus Dharmodas Ghosh. Whatever we have discussed in the Mohiri Bibi, the same thing will come in the exam. Otherwise, Balfour versus wife of Balfour, that kind of questions will come in the exam, beta. How to answer that kind of the questions? In 3 steps, beta. Step number 1, we have to explain the provision of the law. Explain the provision of the law. कानून क्या बोल रहा, कानून के अंकों में कैसे रहना, చట్టబద్ధంగా ఎలా ఉండాలి, as per law how we are supposed to be. We have to explain this the section in step number 1. That to point wise, beta, never as para wise. Point 1, point 2, point 3. Section, what section explains, है ना. In step number 2, we should write about the facts of the present case. Facts of the present case. So what was happened in the present question, है ना. We have to write the facts in the step number 2, and step number 3, we have to give the decision. If you write like this, you will not lose even 1 mark also, beta, है ना. Even he want to reduce the marks, he will not have a scope. Examiner will not have a scope to reduce the marks. As per act, he is supposed to be like this, but our client is doing like this. So this is the decision. This is the decision. This is how you have to write the answer for both case law based and practical section based questions. Here we have to refer the case law also, case law based. If it is a section based, no, only section we have to write here, only provision we have to write. If it is a case law based, no, we have to write the provision and also the respect to case law we have to write here, and case law facts. Here what was happened in the question we have to write. Here this is the conclusion. If it's direct question, beta, we have to write directly only without referring any step, without any steps. We have to write the point wise. Hai na, beta? This is how you have to answer the questions in the exam. So let us start with Indian Contract Act. Indian Contract Act, first chapter, beta. Essential elements of valid contract. The weightage of the Indian Contract Act will be nearly 60 marks, sir. How many marks, sir? 60 marks. Total law weightage is 60. Out of law, Contract Act weightage is 24 marks, beta, है ना. 24 marks out of 60 marks, है ना. So let us start with the first chapter of the Indian Contract Act. examination, previous exam questions. This is very, very, very important. This is the real depth of the exam. Then you will realize why people fail in the exam. So what we teach in the class is different. What they ask in the exam is different. So we are seeing the exam depth now. The first chapter, first question. This question was asked for 4 marks, sir, in 2018 November. है ना? See how many lines is there? First of all, question 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 lines is there, sir. Sir, in the exam, 1 second, sir. In the exam, 100 marks are there for the 3 hours. है ना बेटा? That means 180 minutes. For 180 minutes, how many marks are there beta? 100 marks. For 1 mark, how many minutes is there? This is important beta. That is 180 into 1 divided by 100. That means 1.8 minute is there for 1 mark. 1 minute is equal to 60 seconds. 1.8 minutes is nearly 120 seconds. So 100 seconds are there, nearly 100 seconds are there for 1 mark. On average, we are having the 100 seconds is there for 1 mark in the exam. See here, this question, 13 lines question is there for 4 marks. That means 400 seconds are available to you. How many seconds beta? 400 seconds. In this 400 seconds, you have to read the 13 lines question at least 2-3 times, because if you read for the first time, you cannot understand, no beta. So 2 times minimum you have to read. And in this 400 seconds, you have to read the question, you have to read the step number 1, step number 2, step number 3. Is it possible, sir? Yes, it is possible if you do the question before entering into exam. Moreover, I am telling you, sir, the same type of questions will come in the exam. Whatever we are discussing now, the same type of questions will come in the exam. I will give guarantee for that. Hai? So, let us start with the first question, sir. November 2018, 4 marks. So, what is there in the question, beta? Mr. X and Mr. Y entered into contract on 1st August 2018. Underline this in the exam hall also. So, who is entering into agreement, beta? X and Y. Entering into a agreement. When the contract is entered 1st August 2018, agreement is entered between the X and Y. Hai na beta? Clear na? By which X had to supply 50 tons of the sugar to Y at a specified price within a period of 10 days. That means we have to supply the sugar to Y on or before within the when did beta? 10 days anta, within 10 days. That means on or before 10th August 2018 we have to supply the sugar. How many tons of sugar beta? 50 tons of the sugar. Hai na beta? 50 tons of 5 tons? 50 tons beta. 50 tons of sugar we have to supply. X has to supply to Y. Hai na? So, till here you understood beta. Always in the exam, divide the question into number of parts. Don't read the whole question in one stretch. कुछ भी समझ में नहीं आता. Divide the question into some 4 to 5 parts. So first part is clear. Till now we have understood. So X and Y is entering into agreement. As per the agreement is ended on the 1st August, we have to perform the contract only before the 10th August. And as per the agreement, X has to supply the 50 tons of the sugar. Till now clear? Okay. Mr. Y also paid the amount of 50,000 towards the advance as per terms and as per the terms of the above contract. Hai na beta? So what he is saying beta? Buyer, he is the seller. He is the buyer, and buyer paid the advance. Buyer paid the advance also beta. How much advance he paid beta? Buyer also paid the advance 50,000 rupees to X. Hai na beta? 50,000 rupees advance also buyer paid to X. Till now happy. Why also paid the advance of 50,000 towards the advance as per terms of the above contract. The mode of transport available between the places only roadway between X village and Y village. Only one way is there, beta. That is the only roadway. समझ में आया till now? Okay. Roadway. Severe floods came on 2nd August 2018. This is the crux of the question. So what was happened, beta? On 2nd August, flood came and the only road connecting their places was damaged. On 2nd August, क्या हुआ बेटा? Flood came. 2nd August 2018. So because of the heavy rain water, rain floods, है ना? क्या हो गया बेटा? The road was damaged. So how X can go to Y, beta? Only one road and the road was damaged. So this is known as the void contract. Which contract, beta? Void contract. On 1st August, road was there. Everything is possible to reach Vice village. Subsequently, after entering into valid contract, it is impossible to reach the Vice village. है ना बेटा? So when impossibility comes, no, contract becomes void. Contract becomes void. That is what you have to understand the exam hall, beta. See, देखो क्या हो? Severe floods came on the 2nd August and the only road connecting their places was damaged and could not be repaired within the 15 days. है ना बेटा? So when the road was damaged on 2nd, it became impossible to perform the contract. It becomes impossible to perform, है ना, from 2nd August. And the road cannot be repaired till the 15th August 2018. है ना बेटा? So, but we have to supply the sugar only before the 10th August. When बेटा? 10th August. है ना? But unfortunately, road was damaged. We cannot perform the contract till the 15th August. It is said to be on 2nd August, contract becomes void. Void contract, which will discharge as the both the parties. That means X need not give the sugar, Y need not give the money. Yes or no, sir? But all Y gave the advance of 50k. So X has to give it back to Y again. है ना? So severe floods came in the 2nd August and the only road connecting their places was damaged and could not be repaired within the next 15 days. That means till the 16th August it cannot be repaired. X offered to supply sugar on 20th August. X said, my dear Y, so since road is damaged, I cannot come to your village. As per the contract, I have to supply only before 10th August, but I can't reach you because road is not there. Do one thing, I'll supply the sugar on the 20th. Let us see Y is agreeing or not for that. So X offered to supply sugar 20th August, for which Y did not agree. Y said, no. I don't want the sugar on 20th. I want it before the 10th only. So X said, I can't come to your village before 10th because road is not there. And not Bhagavan, no. How can I come to your village without road? So that means contract becomes void here. Void contract from the 2nd August itself. So on 1st September 2018, Y claimed compensation of the 10,000 rupees from Y for refusing to accept the supply of the sugar, which was not there within the purview of the contract. X said, I don't want the sugar after 10th, and Y said that I don't want the sugar after 10th. Since Y is not accepting the sugar after 10th, X said, you have to give me 10,000 rupees. You have to give me 10,000 rupees. Can X claim 10,000 rupees, beta? Can X claim 10,000 rupees? Answer is no. He can't claim because this was not then, this condition not then the contract. No, he's saying here, see, X claimed the compensation 10,000 rupees from Y for refusing to accept the supply of the sugar, which was not there within the purview of the contract. Why said that? Why never said that I'll give 10,000 rupees? No, beta. So X cannot claim any 10,000 rupees. On other hand, Y claim the refund of 50 from the X. So Y is claiming the refund of 15. Whether Y can entitle to claim beta from X? Yes. Y claims refund of 50,000 rupees from X. Can is eligible beta? Yes. Because whenever contract becomes void, no beta, there is a principle of restitution. RESTITUTION. Restitution means return of benefits received. For example, I am receiving a benefit of pen. I have to give it back to you. You are getting a benefit of 10 rupees. You have to give it back to me. No, beta. If the contract becomes void, so you gave an advance to me for singing a song. I am unable to sing. I have to refund your advance. No. So why give the advance of 50k? Why is he eligible to get the refund of 50k? But can he exclaim 10k from the why beta? No. He cannot claim 10k from the why. Which had why claims the refund of 50k which he has paid as advance in terms of the contract. Okay, this is the question beta. From here, main question, analyze the above situation in terms of the provisions of the Indian Contract Act and decide on why's contention. Contention means intention. So why give the advance of 50k to X and why is demanding his 50k refund? Whether why is eligible to the refund beta? Yes, because contract becomes void. Beta. So how to read this question beta? How to read this kind of the question? Beta, here we should answer this question in 3 steps beta. Step number 1. Step number 1. Provision of the law. Provision of the law. इसमें क्या लिखना बेटा? We should write the act. We should write the definition of the void contract. Definition of the void contract. And we have to write about the effects of the void contract. Effect of void contract. That is restoration of the benefits or restitution. RESTITUTION. Step number 1 is, in this step number we should have these 2 things beta. In step number 2 में क्या लिखना beta? So what was happened in the present situation we have tried. Step number 2, we should write the facts of the present case. So इसमें क्या लिखना बेटा? What was happened? So what was happened in the question beta? See, X and Y entering agreement on 1st August 18 to perform it on or before 10th August 18. है ना बेटा? Subsequently on 2nd August 18, because of the floods, performance become impossible. Performance becomes impossible. Beta. And what we have read beta? So Y gave advance of 50,000 and he's demanding it back. And Y demands it back. Demanding it back. And what was happened beta? And X agrees to supply sugar on 20th August 18, which was not agreed by Y. Which was not agreed by whom beta? Y. And X is demanding the damage of 10,000 from Y for not accepting. Performance on 20th. है ना बेटा? This was happened in the question. है ना बेटा? So step number 3, what we should read beta? Conclusion or the decision. Decision. ये क्या है बेटा? Decision. ए decision में क्या लिखना? देखो बेटा. ए decision में क्या लिखना? First, since the only road road connecting X and Y is damaged, is damaged, contract becomes what beta? Contract becomes void. Contract becomes a void or void contract, है ना? And X need not supply sugar, need not supply sugar, and X has to refund advance of 50,000 rupees to whom beta? Y. And one more question is there beta, can X claim the 10,000 rupees from Y? No. X cannot claim 10,000 rupees from Y because it is not specified in the agreement. Not specified in the agreement. है ना बेटा? So he gave the question for 4 marks beta. If you write like this, do you feel that he will reduce the marks? Chance is not there. Here he will give 2 marks. Here he will give 1 mark. Here he will give 1 mark. Even he want to reduce the mark, he don't have any scope to reduce the marks. This is how you have to answer the question in the exam. है ना बेटा? So let us read the answer also once. है ना? So question is clear ना बेटा? So answer. First क्या लिखा है इधर? क्या लिखना है इधर? Provision of the law. Subsequent impossibility or supervening impossibility or event becomes impossible after entering into contract. That is a void contract. Which contract beta? Void contract. Definition. Void contract means a contract which ceases to be enforceable becomes void when it ceases to be enforceable. Section 2I. Don't write section number in the exam unless you are confident. Don't write wrong section number. If you're confident, write it. Otherwise, don't write. So here we are defining, we are explaining the definition of the void contract. And when performance becomes impossible, here performance becomes impossible because of the floods. Impossible or illegal by occurrence of any unexpected event or change of circumstances beyond the contemplation or beyond the expectation. Contemplation means expectation. Beyond the expectation of the parties, contract becomes void. Void contract ho jata. So effects of the void contract. Also, as per section 65 of the Indian Contract Act 1972, when an agreement discovered to be void or becomes void, or when the contract becomes void, any person who has received any advantage under the agreement or the contract must restore it. Here, X has taken the advance of 50k from the Y. X has to refund the 50k to the buyer Y. है ना? Restore it or to make the compensation for it to the person from whom it is received. So this is the void contract definition and its effect we have explained in step number 1. So even examiner want to reduce, he will not have any scope. He cannot reduce beta, chance is not there. The facts of the present case. What was happened in the question beta? In the given question, Mr. X and Y have entered into a contract for supply of 50 tons of the sugar. The event of flood occurred on 2nd August, which made it is impossible to deliver the sugar. That means from 2nd August, from the 2nd August, contract becomes void contract. Impossible to deliver sugar within the 10 days. है ना बेटा? Decision. Since promise in the question becomes void due to impossibility of the event, है ना? Further, X has to pay back the amount 50k that he has received from the Y as an advance for supply of the sugar within the stipulated time. Hence, the contemplation of the Y is right. Y is demanding back his advance. Beta, this thing pakka you have to write in the answer because in the ending of the question, what was there beta? Decide the Y's contention, Y's intention. That thing, if you don't write, no, he will not give full marks. Out of 4, he may give you only 2 marks. Therefore, hence, contention, intention of the Y is correct perfectly. Y is demanding back his 50,000 rupees advance. समझ में है बेटा? So this is how questions will come in the exam, and this is how you have to answer the questions in the exam. Let us go to second question, sir. है ना बेटा? So let us start the second question, sir. Second question from the previous exam question paper, sir. The second question, this question was asked for 3 marks in November 2018. That means you should answer this question with step 1, step 2, step 3 in 300 seconds. How many seconds, sir? That is very important, beta. Make sure that you are completing 40 marks in first 1 hour. So for this I made a video in the YouTube. Please check it in my channel, sir. So how to use 3 hours time in the exam, one video is there, please check it. So this question we have to answer in the 300 seconds along with the answer. So the same kind of question was asked once again in the ICS practice questions also, beta. See, Mr. Ramesh promised to pay 50,000 rupees to his wife, Mrs. Lali. So husband name is Ramesh, wife name is Lali. So what was happened, beta? Here there was an agreement between the Ramesh and his wife Lali. Who is there, beta? Ramesh is there, and Mrs. Lali is there. That is wife of Ramesh. Ramesh promised to pay 50,000 rupees to his wife Lali so that she can spend the sum on her 20th happy birthday. So, husband promised his wife to pay 50,000 rupees as a birthday gift. As a birthday gift. So, understand, beta? Always divide the question into 4 to 5 parts, beta. So, till here, first part is over. Mrs. Lali insisted her husband to make the written agreement if she loved her. So Mrs. Lali said, I want it on the white paper. I don't want orally. I cannot believe you, my dear husband. My dear husband, give it on a paper. Mr. Ramesh made a written agreement and agreement was registered under the law. Mr. Ramesh fails to pay the specified amount to his wife Lali. So Ramesh said, I will give you money. Subsequently, Ramesh fails to pay the gift to her wife. Mrs. Lali wants to file a suit against Mr. Ramesh and recover the promised amount. Referring to the applicable provision. See here, what he is saying, beta? Referring. That means he is asking you to. See what he is saying, beta? Referring to the applicable provisions of the Indian Contract Act. He is asking why she can win the case, why she cannot win the case. That means he is asking specifically step number 1, provision of the law we should write. If you don't write provision of the law, you will not get the marks. So referring, he is asking you to refer the provision also, referring to the applicable provisions of the Indian Contract Act 1872. Decide whether Lali will succeed. Question was asked for 3 marks, beta. Beta, this question, same question came again. A husband agrees to pay his wife certain amount as maintenance every month while she was in abroad. Husband fails to pay the promised amount. Wife sued him for the recovery of the amount. Decide as per Indian Contract Act whether the suit wife is maintainable. Beta, this question can be answered in 2 ways. One is domestic agreement. The respective case lies Balfour versus wife of Balfour or Mrs. Balfour. This is one of the method. And another way to answer this question is consideration chapter. Exceptions to no consideration, no contract. Agreement made on account of natural love and affection. But unfortunately, examiner is giving this answer in his answer sheet. That means examiner is treating it as a domestic agreement only. So how to answer this question? Let us try to understand, sir. Step number 1, step number 2, step number 3. So see. Step number 1, provision of the law. Step number 1, provision of the law, domestic agreement. Which agreement, beta? Domestic agreement. Balfour versus Balfour or Mrs. Balfour. There must be an intention on part of the parties to create the legal relationship between them. Social and domestic type of agreements are not enforceable in court of law. Hence, they do not result into any contracts. They will die as the agreements. If you don't read this kind of wording in the exam, you will not get the marks. Professional wording also important, jargon also important. So, if you observe in step number 1 itself, I am referring the Balfour versus Balfour case law also beta. Facts of the case. Facts of the Balfour versus Balfour. Husband was employed in the Ceylon. He returned with his wife to England on a leave, but she was unable to go back to Ceylon with him due to medical reasons. She was admitted to hospital. So he consequently promised orally to make a allowance per month until she rejoined him. But Balfour fails to make the payment and Balfour sued him. So what was happened in that case? La decision. Beta, this is all step number 1 only. In step number 1, I am explaining the domestic agreement and the Balfour versus Balfour. है ना? This is case lab based practical question beta. Since the agreement was made ordinary domestic relationship of husband and wife out of amity and necessity, the intention to enter into legally binding contract is missing. There is no legal binding contract, and hence there was never a contract between the Mr. and Mrs. Balfour. है ना? So wife will not win the case because it's domestic agreement. This is our step number 1 beta. In step number 1, I have explained domestic agreement and also the Balfour versus Balfour case law. है ना beta? See how to answer this question beta. Second question है ना, प्रोविजन ऑफ लॉ में क्या लिखना, we should write the meaning of domestic agreement and we have to explain the Balfour versus Mrs. Balfour case law है ना. This is what we have to explain in the step number 1. In step number 2 क्या लिखना बेटा, wife agrees to pay money to husband agrees to pay money to wife, subsequently fails to pay the money to wife. तो इसमें क्या लिखना बेटा, husband agrees to pay money to his wife as birthday gift, subsequently husband fails to make the payment. Fails to make payment to wife. So wife sued husband. So this was happened है ना बेटा. ऐसा लिखे तो why he will reduce the marks बेटा, even he want to reduce he can't because he don't have chance to reduce the marks है ना, chances नहीं है उसको है ना. Step number 3, since it is a domestic agreement, not enforceable by law, wife cannot succeed in the suit. Khatam. You will get 3 out of 3. Even he is giving the 2 marks here, half mark here also. Still you will get the full marks, no matter. So where is the chance of reducing the marks? You will get the full marks. This is how we have to answer the case law based practical questions beta. समझ में बेटा? Let us go to next question sir. Fourth question. Point out with the reason That means he is asking the logic also. Point out with a reason whether the following agreements are valid or void. He is asking the agreement is valid agreement or void agreement. If you saying valid, why? Explain the reason. If you're saying that void, why? Explain the reason. So what we people will do in the exam hall? You will say valid contract, void agreement, voidable agreement. Don't read the logic, no. Out of 2 marks, he will not give half mark also. He will give you 0 marks because he need the logic. He need the logic. So, but the first question, Ria promises with Samarth to lend 50,000 rupees. So 5 lakhs rupees beta. क्या हुआ इधर? Ria he is there beta and Samarth is there. Ria said to Samarth, "Arey Samarth, I will give you how much? 5 lakhs rupees. Fine, let us see. I will give you 5 lakhs rupees in lieu of consideration that Samarth gets Ria's marriage dissolved." अब क्या बात कर रहे हैं? So actually Ria was already engaged to Rohit. Ria was already engaged to Rohit, but Ria don't like the Rohit. Ria don't like the Rohit. Ria loved the Samarth. Ria said to Samarth, "I'll give you 5 lakhs rupees if you break the engagement between the me and Rohit." You have to break the engagement between the me and Rohit. And I'll give 5 lakhs rupees. Chalo, what is there still? And he himself marries here. So Ria said to Samarth, "I'll give 5 lakhs rupees and I will marry you also. I will marry you if you break the engagement between me and Rohit." But what is the nature of the agreement? Bad agreement. Bad agreement. This agreement is opposite to public policy. Agreement between the this Ria and Samarth is opposite to public policy. Opposite to public policy. Gully's agreement है ना बेटा? Breaking the relationships, breaking the marriage. बेटा whether it is valid agreement? Agreement is perfectly void. It is void agreement. Yes or no, sir? Let us see the answer also. See, it is a void agreement. Which agreement, beta? Void agreement as per section 23 of the Indian Contract Act 1872. If you don't remember section number, don't write. Write like this. As per the provisions of the Indian Contract Act. As instead of section 23, as per the provisions of Indian Contract Act. If you're sure about section number, quote it. Otherwise, don't quote. As per the section 23 of the Indian Contract Act, agreement is void if the objective or consideration is against the public policy, opposite to public policy. So he may give you 1 to he is giving the 4 marks for 4 questions. You will get a 1 mark. If you will get the 1 mark if you read the logic. Don't write logic, write only void agreement. He will not give you half mark also. So this question was asked in 2019 beta for 4 marks. Second one is MTP question beta. Model test paper before the exam. So ICA will conduct a model exam. This question was asked in the model exam beta. Second question, Aryan agrees with Madhav. Aryan agrees with Madhav to sell his black horse. Which horse beta? Black horse. Unknown to both the parties, horse was dead at the time of agreement. Oh, क्या बोल रहा है इसमें? What he's telling beta? Aryan said to Madhav. Aryan said to whom beta? Madhav. Hey Madhav, will you purchase my horse? Will you purchase my black horse? है ना? ये क्या है बेटा? A black horse. So Aryan said to Madhav when 10 o'clock in the morning. अरे Aryan, अरे Madhav, will you purchase my horse for the 5 lakhs rupees? है ना? But unfortunately, this horse was deceased at 9 o'clock. Horse was dead at 9 o'clock. Both Aryan and Madhav don't know that horse was deceased. It is a bilateral mistake. Which mistake, beta? Bilateral mistake. So it is perfectly void agreement. Beta, they're agreeing to sell the horse but not dead body. Unfortunately, when they're selling the horse, no, before that time only it become dead body. And beta, since horse is not there, no, it is a void content void agreement, void agreement, because they planning to sell the horse at 10 o'clock, but horse was deceased at 9 o'clock. At 10 o'clock, horse is not there. They're selling something which is not existing, which is not existing. See here what he is saying, beta. Aryan agrees with Madhav to sell his black horse, unknown to both the parties. दोनों को नहीं मालूम. So unknown to both the parties, the horse was dead at the time of agreement. Agreement was made at 10 o'clock. Horse was deceased at 9 o'clock. So both of them don't know that horse was not there. They're selling something which is not there. So that is a void agreement. It is impossible to sell the horse because horse is not there. So answer is void agreement. It's a bilateral mistake also, moreover. Void agreement. As per section 20 of the Indian Contract Act, a contract caused by mistake of the fact is void. There is a mistake of the fact as to existence of the subject matter. Horse is not in existence. So agreement is void agreement. So you will get the 1 mark if read like this. Third question. Ravi sells the goodwill of his shop to Sham. तो क्या बोल रहा बेटा इधर, गुडविल बेच रहा. Who is selling beta? Ravi is selling his goodwill. Shop and goodwill also beta. Ravi is selling the goodwill of the shop to whom beta? Sham. Ravi is selling it to Sham. For how many lakhs beta? 4 lakhs. 4 lakhs. Happy. And promises not to carry on such business forever and anywhere in India. Beta, it is a restriction on the business. Restriction on the business. Everybody has a right to do any legal business. But here said, Ravi said, you should not do the same business anywhere in India. Beta, for example, Ravi and Sham are there in Hyderabad. This is India. Assumption. This is Hyderabad. So contract is happening here. Ravi and Sham. Clear na? So Ravi is paying the extra money to, so Sham is paying extra money to Ravi, 4 lakh extra. That is goodwill, name and fame. Why? Because that shop is famous in the Hyderabad. So buyer can restrict the seller. Buyer can restrict the seller of the goodwill. Don't do same business in Hyderabad. Restriction is valid. Don't do business all over the India. Restriction is void. Don't do business in the Hyderabad for next 5 years. Restriction is valid. Don't do business forever. Void. Forever means void. Clear na? Because I cannot enjoy your goodwill beyond 4 to 5 years. So, here crux is forever and anywhere in India. So since it is opposite to trade, opposite to lawful business and profession, opposite to public policy, it is void agreement beta. See? Void agreement. As per section 27 of the Indian Contract Act 1872, an agreement in restraint of trade is void. Agreement in restraint of trade is void. However, buyer can put such condition on the seller of the goodwill not to carry on the same business. However, the condition must be reasonable. Forever is not reasonable. Regarding the duration and place. Duration 4 to 5 years reasonable. Forever not reasonable. Place in Hyderabad reasonable. Anywhere in India is not reasonable. So it's apart to public policy. It is a agreement in restraint of trade or profession. Void agreement beta. 1 mark you will get it if you write the agreement in restraint of trade along with this logic. However, agreement in restraint of trade is void. Exception is the goodwill and condition must be reasonable period and reasonable duration. Reasonable business or same business. Same business and reasonable duration, reasonable place. Last question beta. In an agreement between the Prakash and Girish, there is a condition that they will not institute legal proceeding against each other without consent. ये क्या है बेटा? 2 parties are there beta here. Girish is there, Prakash is there. Girish is there, Prakash is there beta. For example, Prakash is selling a car to Girish. So Prakash has to give the car, and Girish has to give the 5 lakhs rupees. Prakash said to Girish, Prakash said to Girish, if I don't give car, if I don't deliver the car, even you give the money, you should not sue me. Girish should not sue Prakash. In the same way, Prakash gave the car. Girish, if Girish does not give money, if Girish does not give money, Prakash should not sue Girish, है ना बेटा. Everybody has a right to go to court of law for justice if other party makes the breach, but this agreement is restricting the parties to approach court of law. This agreement is agreement in restraint of legal proceedings. So agreement will be void agreement. Which agreement beta? Void agreement. समझ में आया बेटा? ऐसा we have to answer the questions. Clear ना? So an agreement in restraint of legal proceedings is void as per section 28 of the Indian Contract Act. So all the above agreements are the void agreements. If you read the nature of the agreement along with the logic, you will get 1 mark. Let us go to next question beta. Fifth question है ना. So what is it in the fifth question? Let us try to understand, sir. Clear na beta? So let us start with next question, sir. That is question number 5. So what is the fifth question, sir? We have seen the 4 questions na beta. A coolie in the uniform picks up the luggage of R to be carried out of railway station without being asked by R, and R allows him to do so. So what was happening in this question beta? R is there beta. Who is there beta? R is standing in the railway station. And along with luggage, along with his bags. So many bags are there beta? So 5 bags are there, and R is standing in the railway station along with 5 bags. You know? A coolie came wearing that coolie dress. Coolie came along with coolie dress, and he's taken these 5 bags in his hands. Beta, two bags, and 1 bag is on his head. है beta. Coolie came, he has taken the 4 bags in the 2 hands and 1 bag on the head, and is going towards the railway station. है beta. And R is not stopping him. R is not stopping the coolie, and R is following the coolie till the bus stand. Beta, here if you observe, we have discussed the same example in the class also. So taking the luggage by coolie is the implied offer. Which offer beta? Implied offer. Following the coolie by R is following the coolie. Following coolie is the implied acceptance. है ना beta? So between R and coolie, what is there beta? Implied contract is there. What is there? Implied contract is there. है ना? So examine whether the coolie is entitled to receive the money from the R. Answer is yes. Entitled to claim the money from the R. This question was asked in 2018 beta. 2018. The same question came again in the ICA practical question papers. Coolie in the uniform picks up the luggage of the R. If you observe beta, is not changing the names also beta. Ditto question will come in the exam if luck is good. So coolie in the uniform picks the luggage of R to be carried out of the railway station without being asked by R, and R allows him to do so. Examine whether coolie is entitled to receive the money. So how to answer this question? 3 steps beta. Step number 1, provision of the law. क्या लिखना है इसमें? Implied contract. Implied contracts comes into existence by implication. Words are not spoken, words are not written. It is to be understood based on the situation, behavior, conduct of the parties by implication. So most often the implication is by law or by action. Words are not there, only action is there. Section 9 of the Indian Contract Act 1872 contemplates such implied contracts when it lays down that in so far as such proposal or acceptance is made other than words are not spoken, words are not written, the promise is said to be implied promise, contract is said to be implied contract. Here we are defining the meaning of the implied contract. Step number 1. Step number 2, facts to the present case. A coolie in uniform picks up the luggage of R to be carried out of railway station without being asked by R, and R is allowing him to do so. Decision. In the present case, it is a implied contract. Which contract beta? Implied contract, and R must pay for the service of the coolie. So kadam. So this is how we have to answer the question beta. Next question. November 2018 RTP. November 2000 RTP beta. If you observe, we have seen 4 questions previously also beta. Question number 4 is there, no? The same question. This one also. This came in the 2019 4th question, and 7th question is both one and the same. 4 question, 7th question exactly same. This was asked in 2018. This was asked in the 2019. So what is the moral of the story, sir? Same questions will come in the exam. Same questions. Let us see. Same question or not. Kamala promises Ramesh to lend 5 lakhs rupees. There are also 5 lakhs only. 4th question. In lieu of consideration that Ramesh gets Kamala's marriage dissolved. That means Ramesh should break the Kamala marriage with Rohit, and he himself promises here. That means Kamala will marry the Ramesh. Same question, Riya and Samarth. In the place of Riya and Samarth, Kamala and Ramesh came. So remaining same question. Beta, remember, believe me, till CA final, if you do previous exam questions and MTPs and RTPs, ditto question will come in the exam. Ditto question. This is a void agreement. Which agreement, beta? Void agreement, first question. See? Same. As per section 23 of the Indian Contract Act, an agreement is void if the objective or consideration of the agreement is opposite to public policy. Second question. Sohan agrees with Mohan to sell a black horse. Unknown to both the parties, the horse was dead at the time of agreement. Same question there also. Bilateral mistake as to existence. Void agreement. Same question, beta? The same question will come in the your exam also. If you do previous exam question paper. Same, ditto. Third question. Ram sells his the goodwill of the shop to Sham for 4 lakhs rupees. There are also 4 lakhs only. And promise not to carry on the business forever and anywhere opposite to public policy. This is opposite to agreements independent of trade or profession. Void agreement. Third question. Void agreement. Same question. Section 27. Fourth question. In an agreement between the Prakash and Girish, there was a condition that they will not institute legal proceedings each other. Girish and Prakash, same question. Agreement independent of trade. I have a right to file a case on you if you make the default. You have a right to file a case on me if I make the default. But I said, I will not file a case on you. You will not file a case on me even if any one of us makes a default. It is an agreement restricting us to approach court of law. Agreement independent of legal proceedings and void ab initio. See? Void agreement. Restraint of legal proceedings, right to approach court of law. Some extra question came better here. Next question. Let us see what is that. Ramamurthy, who is a citizen of India, enters into agreement with alien friend. But we can enter into contracts with alien friends. It is a valid contract. Which contract, beta? Valid contract, because alien friend is not disqualified. Alien enemy is disqualified. An agreement with the alien friend is valid. So, but an agreement with the enemy is void, beta. Clear, beta? Let us do the next question, beta. Question number 8. Explain the type of contracts in the following agreements under the Indian Contract Act. This question was asked in the 2020 RTP. A coolie in uniform picks the luggage of A. Chusara, sir. The same question is being repeated. A coolie in the uniform picks up the luggage of A to be carried out of the railway station without being asked by A. In the place of R, he is replacing A. Previous question R, here A. And A allows him to do so. It is a which contract beta? Implied contract. 2 marks. See? Implied contract, first question. Implied contracts comes into existence by implication. Most often the implication is by law or by action, but not in words. Section 9 of the Indian Contract Act 1872 contemplates, that means explains such implied contracts when it lays down that in so far as such proposal or acceptance is made other than words, the promise is to be implied. The obligation of the finder of the lost goods. This is second question, beta. This is second one, beta. Next, second question. Obligation of the finder of lost goods to return them to the true owner. This which contract, beta? Quasi contract. Which contract, beta? Quasi contract. What was then, beta, in the question? Example, Rohit is there. Who is there, beta? Rohit. And SG is there. Hai beta? So I am waiting in the bus stand along with my bag. My bus came. I was boarding into the bus and I forgot the bag. I was boarding into the bus. Hai beta? SG was boarding into the bus and he forgot the bag. Rohit found the bag. It is a duty of the Rohit to search for the SG, hand over the bag to SG. Between SG and Rohit, what is there, beta? Quasi contract is there. This question was asked so many times in the exam, but not only once. Quasi contract is there. Which contract is there, beta? Quasi contract. समझ में आया बेटा? Clear ना? See, the obligation of finder of lost goods to return them to true owner cannot be said to arise out of a contract, even it is a remotest sense, as there is a neither offer or acceptance nor consent. These are said to be quasi contracts. Which contracts, beta? Quasi contracts. What is a quasi contract? A quasi contract is not an actual contract, but it resembles the contract, similar to contract. It is created by law. Law is assuming that there is a contract is between the Rohit and the SG created by law under certain circumstances. The law creates and enforces legal rights and obligations. Law is creating a duty to Rohit, and when there is no real contract exists, even there is no contract between the SG and Rohit, law says that, hey Rohit, search for the SG, give it to SG. Such obligations are known as the quasi contracts. In the other words, it is a contract in which there is no intention on part of either party to make the contract, but law imposes the contract upon the parties. It is a quasi contract. Which contract, beta? Asked in May 2020, beta. है ना? Next question in the May 2020. Yeah, 3 questions are there. If we give 6 marks, no? 2 marks, 2 marks, and 2 marks. A contract with B, owner of the factory, for supply of 10 tons of sugar, but before supply is affected, fire accident in the factory, similar to first question. In the first question, floods. Here it is the fire accident. Once fire accident occurs, contract becomes void contract. At the time of entering, there was no fire, valid contract. Before performing the contract, fire accident took place in the factory. पूरा खराब हो गया, everything become ash, है ना? So everything was destroyed. So contract becomes the void contract. कैसे लिखना? देखो, above contract is void contract. Definition as per 2J. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Thus, a void contract is one which is not enforceable by law. By the fire accident occur, the contract becomes the void. समझ में आया बेटा? Clear ना? Next question. 2005 question, sir. Question was asked before your father marriage. We have seen the questions from 1994, sir, till 2021. If you do these many questions, there is no chance that something will come in the exam which we have not done in the class. That is more than sufficient, beta. 2005 question Remember, year is 2005, sir. A father promised to pay his son a sum of 1 lakh rupees if son passed in CA. क्या हो गया बेटा इसमें इधर? Daddy. Father said to son. Father said to son to give how much beta? 1 lakh. If he passed CA. If son passed CA examination in the first attempt, the son passed in the examination in the first attempt, but father fails to pay the money promised. Father is unable to give the money to son. Son files a suit for recovery of the money, state along with the reason. Beta is asking the reason, beta. Explain the provision in the step number 1. State along with the reason whether son can recover the money. Answer is no, because it is a domestic agreement. Which agreement, sir? So, beta same question will come in the exam hall also. See here. Step number 1, provision of the law, domestic agreement. There must be an intention on part of the parties to create the legal relationship between them. Social and domestic type of agreements are not enforceable in court of law. Hence, they will not become contracts. They will die as the agreements itself. The facts in the present case, father promises to pay his son sum of 1 lakh rupees if son passes a examination. In the first attempt, the son passed in the examination in the first attempt, but father fails to pay the amount promised. Son filed a suit on the father for the amount. This was happened in the exam question. Decision. Here, in the given circumstance, son will not be able to recover the amount as it was a domestic social agreement and parties did not intention to create any legal relationship. It will not become valid contract. समझ में आया बेटा? So next question बेटा. Question was asked in 2012, May 2012, more than 10 years back, है ना? बेटा, before 2007 we are having the CA foundation, sir, and moreover before 2017, that is IPCC was there. In IPCC, same Contract Act was there. Now we are calling CA inter, no? In CA inter also Contract Act was there. If you see 2012 question, 13 question, that means CA inter question or CA IPCC question, है ना बेटा? State whether the following statements are correct or incorrect. All contracts are agreements. All contracts are agreements, but all agreements are not contracts. So statement is true, no beta? All contracts are agreement only. Why? Because contract means agreement plus enforceability. Agreement plus enforceability. So all contracts are agreements, but agreements are 3 types beta. Domestic agreements, social agreements, commercial agreements. They will not become contracts. They will not become contracts. Only commercial agreements will become the contracts. So above statement is true statement. All contracts are agreements, but all agreements are not the contracts. Only commercial agreement will become the contracts. They will not become contract. They will die as the agreements itself, social and domestic. समझ में बेटा? See? So, beta, knowing answer is different, writing the answer is different beta. So read how to write the answer. The law of contract is not the law of those agreements which do not create legal obligations. Example, domestic agreements and social agreements and religious agreements. They will not create legal relationships. In other words, the law of contract is not concerned with those agreements where the parties do not have the intention to create legal obligation. In social, domestic, moral, religious agreements, the usual presumption is that the parties do not intend to create legal obligation. So, all contracts are agreements, but all agreements are not the contracts. समझ में आया बेटा? You will get 2 marks for this. So, I give some more questions beta for your practice. Nearly 8 questions are there. We'll do one by one. Question number 11. X contracts with Y, the owner of the factory, for supply of 10 tons of the rice. But before supply is effected, fire caught in the factory and everything was destroyed. So once factory attached to fire, beta, contract become void contract. If you are observing beta, the same question is repeated 3 times. It is there in the ICA module only. That means ICA is asking same question 3 times. That means important. Void contract. Second, a threatened to shoot B if B does not lend him 2 lakhs and B agreed to it, decide the validity. Shooting, agreeing to shoot, threatening to shoot, it is a coercion. It is a coercion. It is a void agreement, void contract, voidable, voidable contract, because consent is not free consent. Is agreeing to sell, is agreeing to lend, because gun is there. If gun is not there, no, he will not sell, he will not lend. I am lending because gun is there. So it is a voidable, it is a voidable, it is a voidable. Threatening to shoot, gun laga diya, consent is not a free consent, not a free consent. है ना बेटा? Understanding the question in the exam hall is important बेटा, है ना? Mr. M agrees to write a book with publisher. After a few days, M dies. So when the agreement is ended, M is there, valid. Before completing the book, he becomes deceased. That means contract becomes void. Dies in the accident, decide the future of the agreement. Agreement will become void agreement. Sorry, agreement will become the void contract. है ना बेटा? So that contract will comes to an end from the date of the death itself. Void contract. Void contract बेटा. Clear ना? Void contract. 14th question. Question number 14. A promised to sell his plot to B for 10 lakhs in cash down, but B pays only 2.5 lakh as the earnest money is a kind of advance money. It's reservation money beta. Earnest money means it's a kind of reservation money. And the promises to pay the balance in the next Sunday. So here B has to pay the money, A has to supply the, A has to transfer the property. Both the obligations are pending. I have to transfer the land on your name. You have to give me 7.5 lakh. On other hand, A promises to gives the possession of the land to B, and B and promise to execute the sale deed on the receipt of the whole amount. In the future, if you give the money, in the future, if you give the money, I'll give you land. I will give you land. So state the nature of the contract in the situation. It is a executory contract. Executory contract or bilateral contract, or bilateral contract, because both the obligations are pending. You have to give the money next week. Next week, after giving the money, I'll give you the position of the land also. I'll transfer the land in your name. Both the obligations are pending. Executory contract. Next question, see beta. A man promises to discover the treasure by magic. But magic is impossible, no beta. I will do magic instead of teaching the classes. If we can able to get something by magic, so it is impossible. It is impossible. Doing something by magic is impossible. है ना बेटा? Decide the validity of transaction. It is void agreement. Void ab initio. Next, what is the difference between the void agreement and contract date? Question beta. Next, difference between the void and illegal agreement. Date question. Last question beta. B promises to pay sum of 5 lakhs to A if A is able to swim across the Indian Ocean from Mumbai. Beta, is it possible to swim the whole ocean beta? We are not human beings. We are human beings. We are not Bhagavan. I am not Hanuman. I am not a Superman. We are the human beings. Can we able to swim the whole ocean? Impossible. Mumbai to Aden anta within a week, that too. Swimming from Mumbai to Aden in a week. So he will die beta. Discuss the validity of the agreement. Agreement will be void agreement because it is impossible. Because it is impossible. This is how you have to answer the questions in the exam, sir. So second chapter we will be discussing in the next class. Have a great time. Enjoy the day. Do subscribe the channel. Take care. SG signing off.